is Miriam Billington. I am the administrator of the Roger J. Traynor Moot Court Competition, and I'd like to welcome you to the final round of the 54th annual Traynor. I want to start by thanking the University of West Los Angeles School of Law. They hosted us for the preliminaries yesterday with a wonderful team of student bailiffs. I would like to thank Robert Brown, the president of UWLA, Jay Frickberg, who is the provost and dean, Jesse Aldava, who's the director of institutional research and e-learning, and Mauricio Cana, library services manager. Jesse and Mauricio helped us on the IT side, and they were so wonderful putting this all together. Thank you to all the judges who helped us yesterday and devoted their entire Saturday to this event. We couldn't do it without you. The Traynor Moot Court was made possible by a very generous grant from the Gisnet Mandel Moot Court Trust, with special thanks to Patrick and Ingela Pigot. And lunch for the judges yesterday was made possible by our gold sponsor, Esner, Chang, and Boyer, with special thanks to Stuart Esner. We will be posting the program, the competition program, that contains a synopsis of the case and information about the competition, the list of all the competitors and the judges. That will all be posted on our website, traynormootcourt.org, as well as a video of this final round. And so all the information is going to be there as soon as we can get it up there. So I would like to thank our justices for today's final round. The justices Helen Bendix, Dennis Perlas, and Shauna Avrith for joining us today. And acting as our bailiff is Professor David Glassman, who is a decades-long supporter of this competition. And so I would like to turn it over to Professor Glassman. Thank you all for coming.
Thank you. Welcome to the final round of the Traynor Moot Court Competition. This year's case is Peter Prescott versus Pacifica University. Appellant Peter Prescott is represented by Benjamin Shin and Ezekiel Garuli. It is my understanding that Mr. Shin will handle the rebuttal and is reserved 2 minutes of time. The respondent is represented by Yash Mehta and Elvis Morales. And unless anyone has any questions or anything further, Mr. Shin, you can proceed.
Thank you, Mr. Bailiff. Good morning, Your Honors, and may it please the court. My name is Benjamin Shin, and with my co-counsel, Mr. Ezekiel Garuli, will be representing Mr. Peter Prescott, the appellant in this matter. Your Honors, I'd like to request to reserve 2 minutes for rebuttal. This case is about a violation of due process rights. Mr. Prescott's right to fair procedure was infringed by PAU throughout the Title IX investigation proceedings based on intimate partner violence. As a result of this violation, a star student athlete, Mr. Prescott, was immediately sanctioned with interim suspension, served an avoidance of contact order, and ultimately expelled from PAU in accordance with the Title IX investigator and coordinator's findings. As such, today I'll be discussing issues 1 and 2 in this matter. As to issue 1, Mr. Prescott was denied his common law right to fair procedure, including the opportunity to cross-examine critical witnesses. As to issue 2, Mr. Prescott did not waive or forfeit his right to cross-examine these critical witnesses throughout the proceedings. Now, turning to the first issue, PAU denied Mr. Prescott his common law right to fair procedure. California recognizes a common law right to fair procedure when certain private organizations have rendered a decision harmful against an individual.
Mr. Shen, in the very beginning of your introduction, you asserted a violation of the due process right. Are you asserting a constitutional right or a common law right?
Your Honor, we are invoking both. It is a constitutional right in the sense that it is a due process right, and case law in California has shown and established that cross-examination in these instances is to preserve the due process rights of Mr. Prescott here.
Why does a private university, why is it subject to a due process right?
Your Honor, in this instance, we have established case law that shows that private organizations must either be guided or reflect the due process rights in administrative hearings where they have rendered a decision harmful against an individual. And such is the case for Mr. Prescott, as there is a Title IX office hearing for intimate partner violence against Mr. Prescott, in which he is sanctioned with interim suspension and avoidance of contact order and was ultimately expelled, the harshest punishment that PAU can enact against Mr. Prescott.
I have an additional question, if I may, Mr. Shin. If in fact that with a private entity, there's a common law right to a fair hearing akin to due process rights, let's call it that, where does that stop? If an employer decides to terminate someone, does that person have the kind of rights you're advocating here?
Your Honor, in these instances, we have unique circumstances where the case and the cause of action for intimate partner violence against Mr. Prescott was based on witness credibility. When witness credibility becomes an issue, and pursuant to the applicable law as established in the controlling case of Ali, Mr. Prescott had a common law right to fair procedure, which includes the right to cross-examine these critical witnesses.
But let me stop you. Why is that more unique than an employee who loses his or her livelihood? I mean, this guy lost his chance at the NFL, I think. Was that it? He was a hot prospect. What about a person who can't support his family or her family?
Your Honor, I may not be quite sure of the exact procedure when it comes to a termination or an issue of employer-employee rights. I believe that case can be adjudicated whether in a court or through a neutral adjudicator. However, in these instances, within the circumstances of PAU, a school campus, and a decision rendered against the student, Mr. Prescott, the circumstances and case law warrant that pursuant to case law and pursuant to California law as established in Ali, Mr. Prescott had a right to fair procedure, which includes cross-examination. And given these circumstances, because the issue turned on witness credibility, fair procedure required that Mr. Prescott had an opportunity to cross-examine critical third-party witnesses that form the basis of the Title IX office's findings.
May I ask one more question? I don't mean to interrupt you all the time.
No worries, Your Honor.
I want to get to your next issue, which is you claim there's no forfeiture here. He's in an odd position to me. He says he did not want to ask her questions or submit questions for someone else to ask the alleged victim. And yet he's now saying, well, he wants everything reversed because he was deprived of his common law fair hearing rights. I don't want to use a loaded term. Okay. Why didn't he forfeit?
Your Honor, Mr. Prescott did not forfeit because if we take a look at the record, specifically AR 292 to 293, we see the correspondence between Mr. Prescott, his counsel, Mr. Marcus, as well as the Title IX office. Once they established that Mr. Prescott and his counsel were not entitled to verbatim responses by critical witnesses or Ms. Pascal herself, it fostered a sense of distrust within the system. Once they proved that, and the Title IX office ensured that they would not be deviating from the proceedings as offered by the disciplinary policy, warranting appellants' distrust in the system. That is when they chose not to attend the live hearing and can serve reasonably as an objection to the unfairness within the procedure and the procedural deficiencies within PAU's disciplinary proceedings. Moreover,
isn't the whole point of the forfeiture doctrine to allow the lower proceedings, whether they start administratively or at the superior court level, to correct error? He's basically not giving that opportunity.
Well, Your Honor.
In fact, he's eschewing it.
Your Honor, during the time when the proceedings took place, and according to then existing law, Mr. Prescott had no basis to raise an objection based on procedural unfairness, including cross-examination. However, there was a change in law as set forth by Ali. Pursuant to Welch and Quorenbaum, California law recognizes an appellant's right to challenge a matter on appeal for the first time if an objection would have been unsupported by substantive law then in existence or based on a change in law that the appellant could not have reasonably foreseen. The court in In re San Antonio ruled that claims are not waived if an objection would have been futile. Here, Mr. Prescott's objection would have been futile based on PAU's established policy outlining specific grounds as to whether or not the appellant could raise an appeal. None of that included procedural unfairness, including cross-examination. Moreover, the controlling case at that time was a 2016 case of USC. In that case law, it did not afford Mr. Prescott a right to cross-examination. However, there was a change in law as set forth by Ali. Ali has showed that when there's an issue of witness credibility here, Mr. Prescott, in light of fair procedure, was minimally required at least to cross-examine these critical witnesses.
Well, that case doesn't bind us, does it?
Your Honor, this case does not bind you. However, the case of Ali does come from the Ninth Circuit, so it does serve as sufficient authority for this court to consider.
Well, sure, but why isn't an examination of a witness by the adjudicator a sufficient basis under a fair procedure analysis as opposed to a due process analysis to test witness credibility?
Your Honor, on that issue, Ali sets forth that fundamental fairness requires at a minimum, one, that a university provide a mechanism by which the accused may cross-examine critical witnesses.
Well, I understand that, but that's the conclusion. My question is, why is that the proper conclusion? Why isn't examination by the person who's going to make the decision a sufficient way to test the credibility of the testimony?
Your Honor, that is sufficient in a sense. However, Ali specifies that for an adjudicator to do this, it must be a neutral adjudicator who has the power to independently find facts and make credibility assessments. There was no neutral adjudicator here. The cross-examination.
That's a different argument, isn't it? Has that issue been preserved? That is the absence of a neutral adjudicator as opposed to the right to cross-examination?
Your Honor, that issue may not have been preserved because in accordance with then existing law and PAU's policy, there was no objection to raise on that basis. However, in 2019, Ali sets forth that when witness credibility becomes an issue against the accused and the accused is facing severe disciplinary action at a private university, then fundamental fairness requires at a minimum that the accused be given an opportunity to cross-examine witnesses, that these witnesses appear in person or by other equivalent means at a live hearing, and third, that there is a neutral adjudicator who is capable of independently finding facts and making credibility assessments. And as such, because there is a change in law now that directly is tailored and applies to the issues here and the circumstances and the facts here, as they readily replicate that of Ali, it shows that fundamental fairness required PAU to now provide Mr. Prescott with these rights as offered in the threefold test by Ali.
I have a question. Is there any difference between the due process required by state actors and the fair hearing required by private institutions? And if so, what is that difference?
Your Honor, there is a difference. In this instance, public universities that receive funding from the federal government are bound by the rules as offered by the state and the Constitution, and private universities are offered more leniency. However, we see that the controlling case of Ali, as well as other case law as offered by Occidental and Westmont, which are private universities, have showed that when there's an issue of witness credibility, fundamental fairness requires that when allegations turn on these witness testimony, the accused must be given an opportunity to cross-examine these witnesses.
What issue of credibility are you referencing here? I'm I'm not sure if this is an issue for your colleague, but
Your Honor,
you go ahead.
Your Honor, there is sufficient issue with witness credibility here.
May I just finish my question? And excuse me then. He admitted, Prescott, I'm using first names, admitted that he grabbed the alleged victim by the neck, pushed her against the wall, and this was corroborated by other witnesses and an admittedly grainy video. What's the issue of credibility?
Your Honor, I would like to
and the reason I'm asking it is some of the case law, you had a true issue of credibility. I didn't consent. Yes, you did consent. You know, that's a real issue of he said, she said, or he said, whatever. But I'm having a little trouble seeing what the issue of credibility is here.
Your Honor, if I may, there is an issue of witness credibility because we see Ms. Pascal has readily recanted her statement, has also raised in her appeal that the Title IX office misconstrued her statement. We see fabrication by the testimony of Coach Paley. We see inconsistency with the testimony of MB2. we see bias with the testimony of MW. And given all of these circumstances, it shows that there was an issue of witness credibility when the Title IX office uses a preponderance of the evidence standard, showing that they relied on the surveillance footage that was grainy, low quality in nature, that only showed the initial interaction between Mr. Prescott and Ms. Pascal without more. Moreover, the parties that were directly involved have showed that have established and expressed that they were not afraid, that they were roughhousing, and they were playing around. The two witnesses who observed this interaction, DH, stated that he did not want to be part of the investigation any longer. Moreover, for MB2, it shows that he was inconsistent with his statement. He gave one statement in the beginning, one statement at the end. There was sufficient issue with witness credibility, and without much expense to PAU and exhausting their resources, acknowledging their need to balance the accused right as well as the accuser's right.
Mr. Shin, you have 2 minutes remaining total.
The accuser's right, and in this instance, it must show that cross-examination is needed here without much of an exhaustion of resources on PAU's part. And all of this just to enforce and uphold Mr. Prescott's right to fair procedure, a right that is given to him under the due process.
I have one question. When does this fair hearing right arise? Did it arise before the interim suspension? Did it arise before he was additionally disciplined?
Your Honor, the fair hearing requirement arises from the onset of the investigation, from the beginning of the investigation throughout the end, whenever necessary and whenever PAU's policy affords, whether it's during the evidence hearing, whether it's during the cross-examination hearing. During all of these instances, as set forth by Ali, PAU must have these witnesses appear in person or by other equivalent means. Mr. Prescott must have been given an opportunity to cross-examine these critical witnesses that form the basis of the Title IX office's findings. And
Mr. Shin, if you wish any rebuttal, your time is up.
And for the foregoing reasons, Your Honor, we'd like to ask that the court reverse the lower court's decision and remand the case for further proceedings. Thank you.
All right.
All right, Mr. Guruli.
Good morning. Good morning, Your Honors, and may it please the court. My name is Ezekiel Guruli, and today I will be discussing issues 3 and 4. Due process is a fundamental aspect of our democracy. It is afforded to the most admirable in our society and to those who are not model citizens. Due process ensures that individuals have access to fair judicial proceedings, and it guarantees that no one is denied their life, liberty, or property without due process under the law. And with this being said, there are 2 issues that I would like to bring before this court. 1, because this case rests on witness credibility, PAU's decision to not allow cross-examination was a harmful error because it impacted Mr. Prescott's ability to present a full defense to the charges against him. And 2, to bring to this court's attention that Senate Bill 493 severely limits PAU's ability to challenge the issues presented before this court. Now, turning to my first issue, cross-examination may reveal potential biases, prejudices, or ulterior motives that influence a witness's testimony. And with this in mind, Your Honors, the respondents will argue that there was sufficient evidence to establish a finding of wrongdoing, and therefore the error is harmless, as cross-examination would not have made a difference in the outcome of the case. But the evidence provided does not support such a finding, Your Honors, as it does not exculpate Mr. Prescott of any wrongdoing absent witness credibility.
What's the standard that we use to evaluate whether there was prejudice?
Your Honors, the standard for harmless error that the appellants believe applicable here is the Watson test set forth in People v. Watson. Now, under the Watson test, an error is deemed harmless unless it is reasonably probable that the outcome would have been different in the absence of the error. And in the case before you, Your Honors, it is reasonably probable that the outcome would have been different. As per the summary of administrative review, a key component in coming to the decision to expel Mr. Prescott was witness testimony. And cross-examination of these witnesses would have revealed that there was ulterior motives, there was lying, fabrications, and hearsay admitted into evidence, which would have weakened PAU's ability to meet their evidentiary burden, Your Honors.
How do we know that?
Your Honors, if we take a look at the record, a key piece of evidence utilized by PAU is a video from the night in question. However, the surveillance video, it's grainy, it's obscured at various moments, and it is hard to see exactly what is going on through the entirety of the video.
And
However,
how would cross-examination have made a grainy video more vivid?
because, Your Honor, the rest of the evidence provided by PAU, whether that be the text messages, the emails, the voicemails, these are not enough when paired with the video to find Mr. Prescott guilty of intimate partner violence. This case turned on witness credibility. And the biggest issue with this video is that it was contradicted by Mr. Prescott and Ms. Pascal. They vehemently contest what is occurring in that video, as they can contend it was taken out of context and that they were simply horsing around as they always do and as they always have.
And that evidence was in front of the adjudicator, correct? And the adjudicator evaluated that, weighed that.
Correct, Your Honors. Now, the respondents will state that Ms. Pascal's initial intake says otherwise. However, we see that Ms. Pascal, in her appeal of Mr. Prescott's decision, we see that she states that she was unsure of what this initial hearing was, Your Honor. She was in a state of emotional distress. She didn't know what questions they were going to ask of her, nor did she know that this would be used against Mr. Prescott in a proceeding, Your Honors. And this, paired with the fact that there is no direct transcript of what was asked of Ms. Pascal, we are unsure how she answered those questions and if the investigator had asked leading questions to get information regarding Mr. Prescott so they could find a finding of guilt, Your Honors. And because Ms. Pascal and Mr. Prescott are key individuals in this proceeding, Ms. Pascal is the one allegedly bringing these charges, Your Honors. Her testimony and her recantation of that initial testimony should be given great credence. Now, another issue that we see with this evidence provided by PAU, Your Honors, is that the text messages and emails do little more than simply reveal the relationships between the witnesses and the parties. And in actuality, these supplemental sources actually reveal that there is a need for cross-examination, as they show that interviewees had potential ulterior motives for testifying the way that they did. For example, I would like to turn the court's attention to the record on AR 19, where it is revealed that MW, who is a key witness in this proceeding, does not get along with Mr. Prescott, and her dislike for Mr. Prescott is explicitly stated in her testimony with the investigator, Your Honors. And in a separate interview, it is revealed that this dislike for Mr. Prescott stems from him staying with Ms. Pascal at her apartment on various occasions. Now, this caused issues with MW and her other housing mates. Text message.
Again, Mr. Garuli, isn't all of that already in the record? That's why you're able to direct us to it. How is there more or different that creates prejudice that wasn't presented by virtue of the absence of cross-examination?
Justice Perlis, as you stated last round, you had asked this question to my co-counsel. This testimony, when they testified before the investigator, Your Honors, the investigator was not in a position of adversarial questioning where they can analyze key instances of an individual's demeanor, Your Honors. When they spoke before this investigator, they were not able to assess whether the individual was visibly nervous, if they were twitching, or if they avoided any form of eye contact. The investigator simply asked them a series of softball questions and took their statements down, which were not recorded verbatim, Your Honors. And this is not the form of adversarial process to assess a witness's credibility. At the very least, cross-examination should have been implemented by PAU as it acts as a guardrail to ensure the accuracy and fairness of these proceedings with little to no extra cost to the university. And there,
I'm going to interrupt you because I want you to answer these questions, and I know time is running out. I'm following up on Justice Perlis's questions. First of all, are you advocating that the cross-examination has to be in person by the accused himself or herself or their lawyers? That's first question. It's going to relate to the second question. It's not unusual to have recanting witnesses in these kind of settings. Domestic violence situations are replete with those examples. I'm hearing you saying that they have to have some kind of cross-examination akin to those in a criminal case, aren't you going to chill victims from coming forward? These are young people, that
Your Honor,
they don't
the
all have
appellant,
lawyers.
Your Honor, the appellants understand this, and at the very least, they should have been afforded the opportunity of cross-examination indirectly. And we see that PAU's procedures when they allowed the submission of questions, Your Honors, this was not indirect cross-examination that could have assessed Ms. Pascal's credibility, as they filtered the questions, Your Honors, and they filtered the answers that Ms. Pascal would provide, Your Honors. We understand the emotional distress that could be undergone from individuals that this occurred with, Your Honors. However, Ms. Pascal states, and going to your second question, that she was not afraid of Mr. Prescott. And in instances that you have described where we see domestic violence or sexual abuse, Your Honors, being afraid and the fear of retaliation by the individual who committed the act is key in why witnesses recant their testimony. But that is not seen here, Your Honors, as Ms. Pascal states in that initial testimony that she was not afraid, and countless witnesses have stated that they were not worried that Mr. Prescott would actually hurt Ms. Pascal, Your Honors. And this is why that recant.
I just like to ask a question about that. Is the school entitled to take the reporting party's safety into account in establishing its procedures? And isn't that different from a criminal proceeding because we're in a private institution setting?
Correct, Your Honors. They can take this into account. However, we see that Ms. Pascal was not afraid of Mr. Prescott, and the only reason that she accepted the avoidance of contact order in the separate housing situation is because she felt obligated to. She states in her appeal that she wouldn't have taken these the housing situation and the avoidance of contact if PAU had said that she had the choice, Your Honors. These were the reasons that she had taken it, and she didn't want this proceeding to occur in the first place, Your Honors. And this, paired with the fact that there's a voicemail provided by an individual that says they blatantly lied in their testimony, Your Honors, shows why cross-examination was needed, Your Honors, and it should have been implemented as some form of guardrail, as it is cost little to no extra cost to the university to implement. Now, this is not the first time that these issues have been brought before California courts. For example, my colleague has spoken to Doe v. Ali. Now, these issues in that case are almost identical to the facts presented before this court. As we see in Ali, the university did not allow the accused student to confront their witnesses through cross-examination, nor were their testimonies recorded verbatim. And in the instance before you, Your Honors, PAU did not conduct any in-person hearings with cross-examination, nor did they record the testimonies verbatim. However, another key aspect of Ali was that there was a limited review of the investigator's finding in the appellate process. Now, these same facts exist in Mr. Prescott's case, as once the summary of administrative review is drafted by the investigator, the fact finding is complete, and neither the misconduct sanctioning panel nor the appellate review panel can challenge the facts or conclusions made by the investigator. But more specifically, Your Honors, if we look to PAU's policies, which could be found on AR 493 and AR 494 of the record, they state that the misconduct sanctioning panel does not reassess or reevaluate the findings of fact or conclusions, and the appellate review panel is not a full rehearing of the facts and conclusions. And because of this lack of review past the investigative stage, the importance of establishing facts and conclusions is paramount. And as such, this denial of cross-examination was a harmful error, as it is the most effective way of establishing witness credibility, especially when the panel deciding Mr. Prescott's fate was making this decision based on a flawed record. Thus, because of these striking similarities to Ali, and because of the numerous discrepancies found in the record with the witness testimonies, this court should find that there was a harmful error in not allowing cross-examination, as witness credibility was central to this proceeding. Now, turning to my second issue, Your Honors, I would like to make clear that SB 493 is not retroactive. However, we ask that this court at least use it as persuasive authority, as it is pointing the way to where the law is now, and there is no reason why this court should not look to what the statute says and honor the rights that it is recognizing.
Well,
as this,
Mr. Garuli, isn't it reasonable to understand what the legislature was doing, was saying the law is not here and private universities are not required to do these things, and we think they should, and therefore starting January 1st, 2022, by that point, we're going to require private universities to do something that they were not required to do before? Why isn't that a reasonable interpretation, particularly given the non-retroactivity of the statute?
Your Honor, it is reasonable. However, this case occurred relatively close in time to the change in law. These issues had not been before California courts until relatively recently, as we see with the case law Ali. And because of this, Your Honor, this is why we ask that this court use it as persuasive authority, as the legislature reacted to an issue that they had seen. And individuals like Mr. Prescott, we do not believe that he should be precluded from these protections that are seeking to address these very issues.
But isn't the non-retroactivity precisely a legislative judgment that somebody like Mr. Prescott should not benefit from these procedures?
Your Honor, we are not asking you to apply the statute in its entirety. We are asking you to simply consider the provisions that are found in the statute and utilize them.
Cross-examination. I mean, that's what this is all about, right? And the statute says you've got to have at least indirect cross-examination, and PCU will adopt that, or presumably has already, but they were given until January 1st, 2022 to do it. Isn't that right?
Correct, Your Honor. But in the interest of preserving Mr. Prescott's due process rights and giving him a fair trial, this decision of expulsion, Your Honors, will affect him for the rest of his life. His prospects regarding his athletic career, future jobs, future collegiate and getting into other colleges and universities, Your Honors, this is something that will have long-lasting effects. And this is why we believe that it should at least be considered. And you're correct, Your Honor, when you state that the statute would include some form of cross-examination, indirect cross-examination. So if this court were to determine that a key case precedent like Ali were not to be applicable, then Mr. Prescott would still be entitled to question witnesses at a live hearing before a neutral adjudicator.
Mr. Gurley, was there any case that predated the effective date of the statute, Justice Perlis and you've been discussing, that required under the common law fair hearing procedure that there be some form of indirect cross-examination? Can you name one case?
Your Honor, I cannot name one off the top of my head, but I'm more than happy to provide a follow-up brief addressing this very issue after the time of this hearing. Your Honors, this case ultimately comes down to a fundamental right: due process. It is in the public's best interest to uphold due process protections, not only for upstanding citizens, but for individuals who might not be modeled. I see my time has expired, Your Honors. May I briefly conclude?
30 seconds.
To protect the due process rights for individuals who may not be model citizens as well. Your Honors, this right is to be granted to everyone, regardless of their race, class, or moral character. And for these reasons, we ask that this court reverse and remand the case to the lower court for further proceedings.
Thank you. Thank you very much.
Mr. Maida, you have 15 minutes.
I believe my co-counsel Elvis will be going first, actually.
All right, Ms. Morales, you have 15 minutes.
May it please the court, my name is Elvis Morales, and I, along with my co-counsel Yash Mehta, represent the University of Pacifica. First, I will address issue 1, why live cross-examination was not required under Doe v. Ali, decided by the California Court of Appeal, Division 4 of the 2nd District, and then issue 4, the effect of statute SB 493 on this proceeding. This is a case about ensuring the campus safety of students and survivors of intimate partner violence. On January 21, 2017, Peter Prescott, a football player who stands at 6 feet tall, weighing 180 pounds, made the decision to physically assault his girlfriend, Jane Roe, while intoxicated behind an alley, and his own actions that night resulted in being sanctioned by PAU. Prescott has received a fair process under common law standards, and the university's determination of the policy violation should be upheld. Fair process under common law only requires notice and a meaningful opportunity to be heard, which Prescott received. A right to any form of cross-examination has only been recognized in a specific set of circumstances that do not apply here. Sexual misconduct cases, where the case hinged on which of the two competing accounts that could not possibly be reconciled was more credible due to a lack of witnesses and corroborative evidence. A right to live cross-examination recognized in Doe v. Ali does not apply here for 3 reasons. First, this is not a sexual misconduct case. Second, Prescott and Roe do not provide competing accounts of the incident. Third, there are witnesses and corroborative evidence. First, every single case that has recognized a right to cross-examination involves sexual misconduct allegations that were committed by strangers or acquaintances. This case falls under the category of intimate partner violence, also called IPV, because these two individuals were in a committed relationship. While sexual assault cases are defined as sexual encounters without consent, IPV is much broader and encompasses both physical harm and non-physical conduct, such as a pattern of coercion. There are two important reasons to distinguish intimate partner violence cases and sexual assault cases. The first is recantation, and the second is re-victimization. A key distinction that requires treating this case differently is that there was recantation by row, which is common among domestic violence survivors. Recantation is a process by which domestic violence survivors take back their initial statements due to fear or coercion or a desire to protect an abuser. Discussion of the uniqueness of domestic violence cases are present in both U.S. Supreme Court and California Supreme Court cases. In Davis v. Washington, the Supreme Court considered the need for flexibility in domestic violence cases, stating that the special nature of these cases is that they are notoriously susceptible to intimidation or coercion of the victim. The court there ruled that 911 calls and other such cries for help in addressing ongoing emergencies and prosecuting criminal defendants, even when the victim did not participate in the trial.
I'd like to ask a question. Is it impossible that a recantation is genuine? That is, are there any circumstances where a person may falsely accuse someone of intimate partner violence and then decide that they should tell the truth? And shouldn't we be allowed to protect against that possibility by providing cross-examination?
Yes, Your Honor, you're correct that not all recantations are false, although a very high rate of them are considered to be or thought of to be false. In the California Supreme Court in People versus Brown, they stated that about 80 to 85% of victims, and the court refers to them as victims, at some point recant. Here, there are factors that point to this being a false recantation. For example, she stated that she was afraid for him to know that she was involved in any way with this investigation. When she took back her statement, she specifically said that it was because she was afraid of retaliation. She was referring to retaliation by the football players, where he's a star football player, but he was also afraid of how he was going to react when he found out and asked for housing, emergency housing, and wanted to have a warning for when he was told that she was involved in any way. She wanted the investigator to make sure he does not know that I was involved, that I brought this forward, because she was afraid. She recanted only 24 hours later.
I'd like to ask you a question. I'm struggling with these arguments in light of the university sexual misconduct policy. It doesn't require sexual violence, does it?
No, Your Honor.
Violence means causing physical harm to the person or to their possessions. This was all over a dog, right? You know, it started over a dog. I'm just having trouble with the distinctions you're making in light of the policy.
Yes, Your Honor. So much of the case law.
And in answering that, didn't he admit that it was I can't remember the exact language, but it's a sexual thing. You know, we were just horsing around. I don't think he used the word horsing, but it's a sexual thing. I'm just having trouble with how to distinguish when you think there's more rights than other situations.
Yes, Your Honor. So here, Prescott was charged with intimate partner violence. That is actually in Section E of the Student Conduct Code. The sexual misconduct charge is under Section B. So he was not charged with sexual misconduct. He was only charged with intimate partner violence. So there are two ways to be found to have committed this conduct. The first is through physical harm, and the second is non-physical conduct. So IPV is very broad, so it does include non-physical conduct where a reasonable person would fear for their safety. And so physical harm is not actually dispositive in this case. But that is the distinction, and all of the case law where cross-examination has been recognized involves sexual misconduct with assailants who were acquaintances or strangers. None of them were in committed relationships, which is why the issue of recantation has not been seen in any case, except for this one. And so, Your Honor, a second distinction here is actually re-victimization. A victim here is at risk of continuing to suffer abuse at the hands of the perpetrator, and cross-examination itself is a very traumatizing experience. It's actually very fraught with drawbacks, which is why even where cross-examination exists, the individual, such as Prescott, for example, will not actually be allowed to be in the same room. And this is because it's such a traumatizing experience. And so, Your Honor,
Well, as opposed to being expelled from a university, which isn't traumatizing.
Your Honor, it is
I mean,
absolutely.
the distinction is focused on the victim, and the need for victim safety is legitimate, but why does that diminish the rights of somebody who is facing expulsion, whether it's sexual violence or intimate partner battering or intimate partner violence? That's really Justice Bendix's question. And the point that you're making, which is, it sounds like you're not suggesting that in a case of sexual abuse, cross-examination would be required. And you're trying to distinguish those cases. It doesn't seem to me that's a very persuasive distinction, given the penalty is identical.
Yes, Your Honor, you're correct that this is a very severe sanction that he's facing, Your Honor. However, there is additional evidence. And so here, cases tend to turn on credibility where there's an absence of evidence and where it's a he said, she said case. That is not the case here. There were third
Well,
party.
isn't the credibility issue whether her initial statement was accurate or her recanted statement is accurate? Which one should be believed?
No, Your
Yeah.
Honor.
Go ahead.
Her recantation also admits that there was aggressive physical conduct. She states that there was rough housing. According to the Merriam-Webster dictionary, rough housing is synonymous with violence. Not only that, but in a text message at the record site 27, she states that the rough housing actually caused physical harm. And she states this after her recantation. So even after her recantation, she's stating that it physically harmed her. The student conduct code does not require intent. So whether he was playing, whether it was harmful, whether it was sexual, that does not matter for the policy violation.
And doesn't matter if there was implied consent because it had happened before?
Your Honor, no, the student conduct code states that he was only charged with the night of this incident. And so what occurred that incident and whether there was physical harm that night is most relevant for the charge here. And those were the circumstances that the university considered.
So it would be irrelevant if under cross-examination she admitted that in prior occasions in sexual interaction, he put his hands around her neck, and that she didn't object to that, and that in fact she at least implicitly permitted it to happen and didn't say stop. That would be irrelevant to an evaluation not only of the actual conduct, but the penalty that was appropriate.
Well, Your Honor, the court did not consider past incidents. It was actually agreed upon that they were only going to charge him with the night in question.
Right, because my hypothetical, and I acknowledge it's a hypothetical, would be there would be nothing to charge in the past because it was in effect consensual activity. And my question is, that might have been revealed with cross-examination. And if so, wouldn't that be pertinent to at least an evaluation of the appropriate penalty, if not whether or not there was a violation itself?
Your Honor, the
Can I
university.
add to that too, that isn't the question of intent also relevant to penalty? That is, intent may not be relevant to a finding that he violated the policy, but it could be relevant to determining whether he would be suspended as opposed to being expelled.
Yes, Your Honor. The university did take into consideration intent as for the sanction, not for the policy violation, which is at issue here. Still, even considering intent, they still found that expulsion was the appropriate sanction here. And Your Honors, this brings me to my my next point. Prescott here, there were two cases in 2021 that stated that ELITE does not apply, where a student has admitted to key conduct of the policy violation. At record pages 173 to 174, Prescott admitted to putting his hand on Rose's neck and gripping her while she was up against the wall. He also admitted at 176 that his actions resemble domestic violence and that he now knows not to do anything that gives the impression of domestic violence in public. The court in Regents 1 weighed in finding for the university that the student stated he understood how someone could conclude it was an easy case closed situation based on the circumstances. Similarly here, Prescott also conceded that the circumstances look bad and that if he himself had witnessed this, a hand on a neck in a dark alley at 1 a.m., he would have reason to ask what's wrong, ensure the victim was safe, and possibly report the incident. Your Honor, Rose's statements also are consistent with the policy violation. She admits physical harm even after her recantation. And not only this, but this case is also distinguished from others where cross-examination was required because there was video evidence, text messages, and eyewitness testimony. Your Honor, opposing counsel brings up MB2. He was a neighbor who had no sort of connection with either party, who witnessed what he saw. Initially, he was hesitant to come forward. He stated that he didn't see anything, that he didn't hear anything. A few weeks later, he had a change of heart and wanted to come forward and do the right thing. This is very different from cases where third-party cross-examination has been found. Dovey Ali extended the right to third-party witness credibility cross-examination based on a case called Doe v. Baum, which was decided by the Sixth Circuit. And there were 23 witnesses. Half of them, the sorority sisters of the accusing party, corroborated her story, while the other half, the males, corroborated the male accused party. And Doe v. Westmont, similarly, it was found that one of the friends of the accused lied about being with him the entire night. Those circumstances are extremely different from the case here as regarding third-party witness credibility. Your Honor, so we have a neighbor who saw everything that happened. We have video footage. The characterization of the video footage is disputed, Your Honor, but what actually occurred, the transcript is not disputed. Prescott discusses it at the record page 60, and he agrees that that is him in the video, that he is making physical contact with her. Your Honor, now to discuss issue 4, which is the statute at issue here. Even if Prescott was entitled to cross-examination at a live hearing under common law, he does not have such a right under Senate Bill 493, which supersedes this case law. Your Honor, there's a retroactivity provision here at issue. The issue here is not the retroactivity of the statute, as the opposing counsel stated. It is the retroactivity of case law. And Your Honors, it is well established that Congress may control retroactivity of judicial decisions. The California Supreme Court and other appellate courts have allowed it. In Forster Shipbuilding versus Los Angeles, the California Supreme Court stated that both the legislature or courts can decide whether considerations of fairness and public policy warrant an exception to the rule that judicial decisions apply retroactively. Similarly, in Marin, the California for the District Division 6 stated that the legislature as well as the court is competent to define the retroactive scope of judicial decision.
Well, but putting aside retroactivity, doesn't this legislative enactment express a public policy view as to what a fair hearing requires, which is what the common law requires?
Your Honor, the statute actually expressly does not require cross-examination. It leaves it up to the university. In the legislative history, it actually considered codifying Doe v. Ali and then expressly decided against it. It said that it was deleting the requirement to require cross-examination. And then it was published as it is today. So the court did actually consider Doe v. Ali. Your Honor, may I briefly conclude?
30 seconds. We asked lots of questions, but 30 seconds.
Your Honor, to finish my response, the bill expressly considered Doe v. Ali and expressly rejected it in the legislative history. The plain text of the statute states that whether any cross-examination or hearing will be required is up to the universities, Your Honor. Common law is very flexible because universities are not required to turn their classrooms into courtrooms. And Prescott does not have a right to cross-examination under common law nor SB 493, and the university's decision today should be upheld.
Thank you.
Mr. Mehta, you have 15 minutes.
Thank you. Good morning, Your Honors. If it may please the court, my name is Yash Mehta, and I am counselor for the University of Pacifica. Prescott had every legal resource at his disposal. He retained a team of lawyers and had sufficient knowledge of his procedural protections. This case is about accountability and, as opposing counsel argues, procedural fairness. Prescott should not be allowed a second bite at the apple because he failed to make a timely procedural argument, especially when there is sufficient evidence he physically harmed Roe. I will now argue the next 2 points. Prescott forfeited any right that he may have had to a live cross-examination of the witnesses, and even if there was any error, that error by the university was harmless. So first, Prescott forfeited any right he may have had to a live cross-examination by failing to request the opportunity to do so during any stage of the proceedings. It is important to note that forfeiture is distinct from waiver. A waiver is an intentional abandonment of a right, whereas forfeiture is a failure to assert that right in a timely manner. In this case, Prescott forfeited his right.
But he didn't have a right under the procedure, did he? And isn't that precisely why forfeiture doesn't apply, as opposed to arguably waiver based on what he and his lawyers said? How can you forfeit a right if you don't have it to begin with?
Yes, Your Honor. It is true that Prescott did not have the explicit right to cross-examination. However, the case at the time, Doe v. UCSD, stated that even though no law requires cross-examination, the case didn't say that cross-examination was not allowed. Prescott still could have asserted that right in a timely manner, and the issue here is that he failed to do so.
The UCSD case involves a publicly funded university, correct? And due process as opposed to a common law right. Isn't that correct?
Yes, Your Honor. However, Prescott still could have asserted that right. He had numerous opportunities to do so, yet he failed to assert that right at any point of the proceedings. In various administrative contexts, courts have held that to assert a right in a timely manner, a party must raise it prior to appeal. In Doe v. Occidental, the Second District Court of Appeals reasons that raising an issue for the first time before the appellate court is unfair, as it prevents the university from responding to the request while subjecting both parties to avoidable expenses and straining an overburdened judicial system. Additionally, despite having a team of lawyers at his disposal, including his mother, Prescott never requested the right to cross-examination when he reviewed and signed the list of procedural protections he was afforded. Prescott and his advisor were in direct communication with the Title IX director, making several requests to alter the procedures to his benefit. He was both granted and denied procedural requests beyond the scope of what he was allowed, demonstrating that he took every opportunity he possibly could to communicate his request to the Title IX director. Yet he never once requested any form of live cross-examination. Additionally, Prescott had no intention whatsoever of cross-examining Roe live. He declined to submit questions to Roe at all and expressly stated that he did not want to question her. On page 2,
isn't the issue really the third-party witnesses and cross-examination of them?
Yes, Your Honor. To be clear, there are two separate issues here: whether Prescott was allowed to cross-examine Roe and whether Prescott was allowed to cross-examine the third-party witnesses. In regards to the third-party witnesses, Prescott had every opportunity to express that right as well. Prescott submitted several written submissions and appeals during the administrative process where he could have raised the issue that he was precluded from cross-examining the third-party witnesses. He took every opportunity to meticulously scrutinize the investigation's procedural misgivings and methodically dissected several of the witness statements, yet never once raised the issue that he had been precluded from cross-examination. There was no good reason for failure to dispute this issue. A request for cross-examination.
I want to make sure I understand what you're saying. Are you saying that he brought to the attention in the various, quote, evidentiary hearings they had, he brought to the attention the problems with the third-party witnesses' statements so it was in front of them anyhow, whether he'd cross-examined them or not? Is that your point?
Yes, Your Honor. Prescott methodically dissected several of the witness statements, yet failed to raise the issue that he was denied the right to cross-examine them in a live setting. There's no good reason for failure to dispute this issue. A request for cross-examination could have solved the inconsistencies and credibility issues that Prescott repeatedly raised. So, Yes, Your Honor.
I don't know what. Well, I'll let you finish. You finish with your next point because the 2 points are related. So I'll let you finish.
Yes, Your Honor. So going back to the issue of cross-examining Roe live, Prescott ultimately canceled the one mechanism he did have to determine Roe's credibility, the evidentiary hearing, and declined to submit any questions to Roe. On page 293 of the administrative record, his advisor even stated that he was not interested in having Roe come in and be put on the spot yet again. Prescott cannot have his cake and eat it too. He should not be allowed a second opportunity to try his case on an argument he had no intention of pursuing in the first place. Finally, it would not have been futile for Prescott to request live cross-examination because he had every opportunity to request this right, and the university never expressly denied it to him. While courts such as those in teacher...
Is there anything in the record that would suggest that Pacifica has ever allowed cross-examination in these types of hearings up to the time that the Prescott matter was heard?
No, Your Honor, there is nothing in the case record that suggests what occurred in past investigations.
So how can we make a judgment whether it would have been futile to ask for that or not?
Well, Your Honor, the issue here is that we don't know what the university would have responded had Prescott requested the right to cross-examination. Had
Well,
Prescott...
we can be pretty sure what it would have responded. I think I can be pretty sure, but that's not in the record, right?
No, Your Honor.
Right.
Prescott did request other procedural alterations to his benefit and was both granted and denied them. He could have asked to be given the right to cross-examination. In cases such as Teacher v. California Western School of Law, courts have held that forfeiture is excused would the request have been futile. However, in that case...
Can I interrupt you? I'm not following where we're going here. It seems what is apparent is that he had no interest in cross-examining her because he could only have dug a deeper hole for himself if he had. He had a completely recanting witness. So what difference does it make? That's why I was trying to wait for your harmless error discussion, but I'm getting a little lost in what's going on in the argument here. Help me out, please.
Yes, Your Honor. I believe you're absolutely correct that had Prescott chosen to cross-examine Roe live, he could have dug himself in a deeper hole. However, what I am arguing here is that it would not have been futile for him to request the right to cross-examination. In other cases...
Well, I'm saying, so what? It would have been harmless. It's harmless error.
Yes, Your Honor.
That's what I'm not following, given the record here, why that isn't the answer to Justice Perlis's line of inquiry. I need some help.
Well, yes, Your Honor, you are correct. And actually that does move me on to my next issue, that any error by the university is harmless because it would be reasonably probable that the university's finding of responsibility would remain unchanged, even if Prescott had been allowed cross-examination. This is because there is significant undisputed evidence outside of third-party witness testimony that shows Prescott physically harmed Roe. The standard here is in People v. Watson, where the California Supreme Court held that an error is harmless unless it appears reasonably probable that the beneficiary of the error would have obtained a more favorable outcome had the error not occurred. In other words, if the outcome of the case would remain unchanged, even if Prescott was allowed to cross-examine the third-party witnesses, the error would be harmless. This is the case here because there is sufficient undisputed evidence outside of the witness testimony that demonstrates that Prescott violated both the Intimate Partner Violence Code and the Avoidance of Contact Order. The first undisputed piece of significant evidence comes from Roe's text messages. Roe's text messages confirm that harmful physical contact did occur. It is also crucial to note that the university standard here is a preponderance of evidence, which just means more likely than not. From pages 27 to 36 of the administrative record, Roe's text messages to her close friends after she recanted her statement state, "He wasn't trying to hurt me at all. He was drunk and just roughhousing. He didn't mean to. I had just never told him, and now that he knows the difference, she trusts that he will not hurt me again." No cross-examination of the witnesses is needed to show that physical harm occurred. These text messages are significant because throughout the entirety of the record, Roe has repeatedly attempted to downplay the severity of the incident.
Well,
Even-
but I was going to ask you, is severity irrelevant and intent irrelevant and prior conduct irrelevant, given the concession that there was physical violence?
Yes, Your Honor, the only thing that the university needs to find that Prescott violated the intimate partner violence code is that Prescott physically harmed Roe.
Then why talk to any of the other witnesses?
You mean
Why bother with the third-party witnesses if the violation is effectively conceded? And isn't the fact that the third-party witnesses, and I mean, I'm asking you questions and somewhat responding to Justice Bendix. It seems to me that prejudice, if there is prejudice, occurs with respect to the failure to allow cross-examination of the third-party witnesses who are going to provide a context for the admission that he did put his hands on her neck and it did harm her. That seems to be undisputed. And my question to you is, if that is enough, why bother with anything else? And if there is a reason to bother with anything else, then why isn't cross-examination of the anything else pertinent?
Yes, Your Honor. The reason that the university decided most likely to include the third-party witnesses is to have the most thorough investigation possible. The severity of the sanctions that Prescott faced were extremely severe. Additionally, the university could have charged Prescott with other incidents, but ended up only charging him with the incident in question at that night.
Didn't they take into account the other incidents in reaching their decision, and didn't that go to severity of the penalty, even if he wasn't charged with those?
Yes, Your Honor, they did take into account the other witness statements. However, any error by the university to not allow Prescott the right to cross-examine these other witnesses is harmless because those witness statements were not needed to show that Prescott violated the intimate partner violence code.
But doesn't it go to penalty? That was the question I had before, that whether or not he violated the code, there's a big difference between being suspended and being expelled. And couldn't cross-examination have made a difference in that regard?
No, Your Honor, because even if the witness statements are completely disregarded, the penalty would have remained the same because Roe's text messages clearly show that Prescott physically harmed her. In addition, Roe's recantation is a pattern that is typical of domestic violence survivors. In People v. Brown, the California Supreme Court allowed the expert witness to testify that 80 to 85% of survivors recant their statements, many in the first 24 to 48 hours. Ultimately, Your Honors, this case is about procedural fairness and accountability. Prescott was never powerless in this process, and the court should not allow him a second chance to try his case due to a procedural right he forfeited, and one that would not change the verdict that, more likely than not, Prescott physically harmed Roe. Thank you, Your Honors.
Mr. Shin, you've used 14 of your 15 minutes.
Thank you, Mr. Bailiff. Your Honors, I have 2 points to make on rebuttal. As Justice Perlis clearly noted, how could Prescott have forfeited a right he did not have to begin with? His objection would have been futile, which serves as an exception to forfeiture and waiver as established in re San Antonio. With the change in law as established in Ali, Prescott may now raise an objection for the first time based on a change in law he did not reasonably foresee. As to my second point, as Justice Averitt has raised, witness testimony was relied here. Thus, witness credibility is an issue. Respondents argued that witness credibility is not an issue, yet we find bias with MW, inconsistency with MV2, misinterpretation and fabrication by Coach Paley, lack of an observation by TS, grainy surveillance video footage that does not show the entire interaction without more, DH, the witness who observed the incident, who stated he did not want to participate in the investigation any longer, and Ms. Pascal herself, who recanted her statement and addressed in her appeal vehemently that her testimony was misconstrued by the Title IX office, and she does not want any victims part of this any longer. Your Honors, may I briefly conclude?
Very briefly,
And for
15 seconds.
And for the foregoing reasons, we ask the court to reverse the lower court's decision and remand the case for further proceedings. Thank you, Your Honors.
Thank you. The case is submitted.
Thank you, everyone. And now the justices are going to confer offline. While we wait for them, I'm going to announce some other winners. The justices now are going to decide who is the winner of this round, which is going to be the Roger J. Traynor Award for the final round. So they're going to do a separate conference call. And in the meantime, congratulations for a fantastic final round to all of you. And congratulations to all the competitors from all of the teams. It was a really exciting competition and a great day yesterday. The judges were extremely impressed with everyone they saw. And we have some awards that we can announce before the big one, before the justices return. First of all, we have the Gisnet Mandel Award, and that is named for the trust, which has generously been providing a lot of the support for the trainer in the past few years. And the Gisnet Mandel Award goes to the team with the highest scoring brief. And this year, the Gisnet Mandel Award for Best Brief goes to Berkeley. Congratulations. Second place is San Francisco School of Law, formerly known as Hastings. Third place is UCLA. And fourth place is Empire. So those are our top 4 briefs. Next, we have the award for Excellence in Appellate Advocacy. That is where we have the team with the highest combination, half brief, half oral, that place in the top half of the oral. And first place again, there is Berkeley. Second place is Loyola. Third place is UCLA. Fourth place is Hastings and San Francisco School of Law, formerly known as Hastings. And fifth place is Empire for the Excellence in Appellate Advocacy Award. We next have an award named for Jeffrey Wright, and his bio is going to be in the program, the competition program that will be posted on our website. So please read about Jeffrey Wright. And the Jeffrey Wright Award goes to the best oralist, and that's based on the Saturday scores. The best oralist is someone who also made the final, that is Benjamin Shin of Loyola. Congratulations, Mr. Shin. We also, after Mr. Shin, the next individual merit awards, the next scoring under him win individual merit awards for oral argument. And again, based on Saturday, we have Kayla Fain from McGeorge, Ezekiel Guruli from Loyola, Kate Walford from Berkeley, Allison Alcocer from Empire, Mariela Soto from Golden Gate, Lisa Talley from San Joaquin, Anna Nabutovsky from UCLA, Kelsey Thwett from McGeorge, Adriana Castro from Golden Gate, Jeremy Templin from UWLA, James Humphrey from Kern County, Yash Mehta, Berkeley, Anne Marie Padilla from San Joaquin. With apologies if I mispronounced anyone's name, those are individual merit awards for best oral argument. Thank you again to everyone. We are so excited that we were able to hold the competition again on Zoom, and the people who were really responsible for that are the wonderful folks at UWLA. So I wanted to thank them again for their IT help and for sharing the campus with us. The bailiffs, who will all be named and thanked in the program, were wonderful, patient, and fantastic, helping us do the rounds. We were all physically together on the UWLA campus to be able to administer the virtual competition. So it was a really involved project, but a lot of fun and very rewarding because everyone from all over the state was able to participate. And our judges also sometimes were located quite a distance from us. So it's great to be able to open this competition up to as many people as possible. And we thank all the judges again, and we thank the participants and the coaches and everyone who made the trainer successful this year. Again, the video of this final will be posted as along with the competition program on traynormootcourt.org. And we all hope that you all sign up, all the schools sign up for the competition next year again. I am going to now mute and black out so I can check on how the conference is going. So let's take a brief pause and we'll come back with the justices and announce the Roger J. Traynor Award and hear comments from our justices today. Thank you so much, and we will be right back.
So is the floor open to the panel now?
The floor is open to the panel. Take it away.
All right. First of all, I have to say we were all very impressed with the high quality and the preparation of all the participants here. I have to make a disclaimer for all of us. We as judges can't ethically discuss the merits of a pending case. So we will not do that here because this is a case that's actively in the Supreme Court. I have to say to all of you, it was a split decision. It was close, but the majority has awarded the Traynor Award to the appellants.
Congratulations to Loyola Law School.
We thought it might be useful to talk about just generally as judges what works and what doesn't work on appellate arguments, and where what we like to see, putting it more positively, in court. And I'm going to start with Justice Perlis, who we both had the privilege to work, if I may digress, for one of the great justices, Shirley Hufstedler, and I consider it a privilege to be on the same court with Justice Perlis.
Oh, thank you, Justice Bendix, and I likewise. I did it a few years before Justice Bendix.
Not many.
I'm a little older than she is. The responsiveness to questions by all four of you was exceptional. Obviously, from the standpoint of a justice, asking questions, I mean, that's why we ask questions. There is nothing that is more distressing than to have an advocate avoid the question, let alone say, oh, well, I'll get to that later, which I'm sure all of you were told at the very, very beginning of your law school. Advocacy was never something that you should do. One of the difficulties, I just want to say, of this format is because the questions are so distinctly divided, that they aren't, in this case at least, they're not that distinct. So to talk about the need for cross-examination and the prejudice that there is without cross-examination and the opportunities to request it and therefore possible forfeiture. I mean, all of those blend together. And in at least in our court, in the real world, we don't have two advocates on each side, at least other than in an exceptional case and with a request. And there, the request would be something very distinct, like two different causes of action, although even there, they tend to blend together. Even in this format, I would say you shouldn't be so concerned that you have issue A and issue B, and feel like when you're talking about A and the question is really as much about B as A, that you can't go to your B, because we want an answer. That's more difficult when it's not your part of the team, and it's your buddy or partner that is going to answer that question. Just one other thing that happened that I thought was terrific, and an observation about something that happened once in my court that was equivalent. I don't know. When you don't know is a terrific answer, rather than guessing. I would be happy to submit a supplemental brief, is a fine follow-up to that. I've heard that a lot. We very rarely ask for the supplemental brief. We often know the answer to the question that we have asked, not always, but we often do. But at one point, I had an advocate, one of the very experienced California appellate certified lawyers, who was asked a question, and he said, "May I take just a moment to think about that before I answer?" And he paused for, it seemed like a long time, but I suspect it was no more than 10 seconds at most, which I understand you're all trying to get a lot of information in a defined period of time. You're going to have a bailiff who's going to say, your time is up, even if you have a presiding justice like Justice Bendix or like I am in my courtroom, which, hey, take as much time as you want, sort of, within limits. But that pause, we were all waiting. I mean, it was very dramatic. And so when it's an appropriate, don't do it in every oral argument. It will look like it's a shtick that you're doing, but it's not a bad thing if you really need to think about it. And he gave an answer that made sense. It was in response to a hypothetical that he hadn't contemplated, I guess. But again, what I want to end with is just saying, one of the reasons I do this every year is that it's always just so pleasurable to see law students who have the skills and were willing to do the preparation that all four of you did.
All right. My next colleague, Justice Harpeth, please.
Thank you. I don't have a lot to add. I did want to say that I was extremely impressed with how well prepared all of you were, and how well you focused on the questions and how well you knew the case law underlying the appellate court's decision in this case. And that's something that in real life people don't always go that deep when they should. So I commend you for that. And this is my first year doing this, and I very much enjoyed it. And maybe Professor Glassman will invite me back.
Are you finished? I wasn't sure. Did you? Okay. I second what everyone has suggested. I always thought when you're in the respondent's position, it's harder to prepare. I mean, you have your, and so it's very important, and you all did it, to listen to how the appellant is presenting the argument and you can't necessarily start with how you were going to start. And you know, in other words, you have to be a little bit more flexible, I guess, when after the appellant sits down. I think it's very important that I'm surprised how many of lawyers who appear in front of me don't do this. But you can really read the panel sometimes a little. I mean, you can tell what's concerning some of them, and you need 2 votes. And so you really be an active listener and watch the panel when they're asking questions and when they're looking at each other, because you get a lot of information actually from that. Unless you have extremely good actors on the bench, you can pick up what's concerning of some of the of the panelists. And I thought that Justice Perlis made very clear what some of his concerns were, and I think I did as well. And make sure you always address those and deviate from your script. That's hard to do in the beginning, but when you're more experienced, you have to be fluid in what's being presented to you, either from the other side or from the panel. It's interesting. Sometimes the panel, I think, focuses on an area that surprises the lawyers a little.
Justice Bendix, may
Yeah.
I add something, which again is really less applicable in a moot court situation
Yeah.
than the real world, but you all will be in the real world presumably pretty soon. What Justice Bendix said is, remember that you need 2 votes. The corollary to that is you don't need 3. And sometimes in some courts, and particularly when you're arguing, as probably all 4 of you ultimately will have the opportunity to do in the California Supreme Court, where you need 4, you don't need 7 out of 7, is you don't want to get so caught up. I mean, you need to be responsive and respectful, but you don't want to be so caught up in one of the justices who seems to be an outlier to what the other justices are asking you, that you lose the opportunity to keep or to persuade a majority of the panel. And it's hard to do if you're well prepared and you have an ego, as I did, still do. You want everybody to agree with you. And so you end up engaging with the active dissenter, even though you don't know it's going to be a dissent. It's just something to bear in mind. As I say, a little less applicable, I think, in a moot court situation.
Well, it's especially difficult, I think, on Zoom. When you're in the live courtroom, you can pick up a lot, actually. I wonder, Mr. Glasson, what you think about that, since you're a repeat player in the courts, but.
I think it's a complicated conversation because I think we enjoy as human beings, we enjoy the interaction in the in-person environment. But I think, for example, to apply some of the benefits here, this is a competition that allows for students and other associated people the opportunity to attend this event and participate at a fraction of the traditional expense.
Oh, no, forgive me. I meant in the real world.
So in the real world, I think largely the same. It allows for remote participation. I personally think, since you asked, that we have many lawyers in the criminal context who avoid oral argument to the point of paranoia. And there's really no justification for that when the arguments are remote. It's simply a matter of getting on the camera. And so I think oral argument should take place when someone's liberty is at stake. If it's worth a brief, it's worth showing up. And I think it also allows interested parties to observe the proceedings remotely, which I think is an important part of the process that very few people can afford to do for in-person presentations. So ideally, I think both will continue to operate, but I'll regret it if we revert entirely to in-person presentation.
Well, they're redoing the courtroom so that they won't that will not happen. So anyhow, I don't have anything more to say, and I just thought this was really a superlative moot court presentation. All three of us applaud all of you as well as the wonderful administration that made this possible.
Exactly. Absolutely. All right. Thank you all very much and good luck with the rest of your law school careers.
Yes, we'll see you in court,
Looking
one
forward
way
to it.
or
Thank you.
another. Okay.
Thank you.
We're bringing down the gavel on Traynor 2023. Thanks to all who are here today and everyone from yesterday. And check out the website for all kinds of goodies, including a recording of this session.
Is it inappropriate to ask who was the other school?
Oh, I'm so sorry. Yes, the runner-up today was Berkeley. So we had Loyola as the appellants and Berkeley as the respondents. And
Well, congratulations to your professors. They prepared you all well.
Well done, everyone.
Very
All
well
right.
done. Congrats again and enjoy the rest of your day. Everyone should be celebrating. It was wonderful. See you next year, everyone.
You're kidding.